Hello everyone, welcome to Clat 1. Today we would be discussing remedies for breach of contract, which is an integral part of the law of contracts and which can come in your Clat examination. Um, so let's see what the remedies are for a breach of contract. So what exactly is a remedy? So, when someone breaks a contract, the law gives the other person option to fix the harm. These options are called remedies. In short, remedies try to put the harm party back in the position they would have been if the promise had been kept. Okay, there are two types of remedies that are money based and non-money based, which are also called monetary and equitable. Okay, so in monetary, there's damages and liquidated damages. They're a bit different. It's not exactly the same. And in equitable, there's a specific performance under which there's injunction, rescission, restitution, and quantum merit. So let's first see the monetary remedies, which is damages. So damages is the money paid by the party who broke the contract to cover the real financial losses. The goal is to put the other person where they would have been if the work was done as promised. So let's see it by an example. A vendor fails to deliver goods. The buyer is paid the extra amount it costs to buy the same goods elsewhere. Okay. So this is the meaning of damages. So the goal of damages is to put the other party to the place where they would have been if the work was done as promised in the contract. Okay, let's see liquidated damages. It's a bit different. Okay, so liquidated damages is a set amount of money written into the contract beforehand that both sides agree to pay if the agreement is broken. So generally, what happens to recover damages? There is a legal suit. Okay, so there's extra, legal burden, court fees, etc. So liquidated damages is a set amount of money which was put into the contract beforehand that if any of the parties fail to complete the contract, they would have to pay. Okay. Both sides know in advance exactly what will happen if the deal falls through, and there's no need to prove the exact loss later in most cases. An example is a contract says 50,000 rupees will be paid if either side backs out. Okay. So this means that if any of the parties backs out of the contract, 50,000 should be paid by the that party. Okay. It is an agreed fixed amount and no separate calculation is needed. Next is specific performance, which is the second type of which is a type of equitable remedy. Okay, so a court orders that forces the party who broke the promise to actually finish doing what they agreed to do. Okay. So it says that if any party stops performing a contract in between, the court orders them to complete the performance of the contract. It can be used when money alone can't fix the harm, like when the item promised is one of a kind, such as a piece of land or a rare painting. And it cannot be used when it's like a personal work, like forcing someone to sing, paint, or stay married. Okay. So if there's, let's say, if someone stops singing in between, I cannot sue the party for specific performance, saying that you have to complete this song in a concert, let's say. Okay, so there are times when you can use a specific performance, and there are times when you cannot. Next is injunction. So injunction is also an equitable remedy. It says that a court order that tells a person to stop doing a specific act that breaks or hurts the contract. Think of it as a legal stop sign. It does not force someone to do something. It stops them from doing the wrong thing. Okay. A simple example to it is an employee agrees not to join a rival firm, and the injunction can stop them from doing so. For example, if my contract says that I cannot join another firm, let's say under 3 years of my contract, signing the contract, injunction stops me from joining a firm under 3 years if I plan to do so. Okay, so this is what injunction means. Next is rescission, which means canceling the contract completely. So both sides are free from their duties. So what does it mean? It's like pressing an undo button on the whole deal. Neither side has to keep any promise made under it, and the wrong party can still sue for damages suffered. The key point for this is the contract is treated as if never happened going forward. So this is mostly used in case of fraud, misrepresentation, undue influence, when the parties uh, were wrongly forced into a contract, and they can ask the court to order a rescission, and they go to their previous state. The money is paid back but to them, and the contract is completely denied. Okay. Next is restitution and quantum merit. So restitution means that giving back money, goods, or property to return things to how they were before the deal was made. This means I give it back. Okay. And quantum merit is a bit different. It means that asking to be paid a fair amount for the work or goods already provided before the contract was broken. Okay. So quantum merit generally means is uh, pay for what was done by you. Okay, for example, if I'm into a contract for building, like, let's say a six-story building, if I make four stories and I stop performing my part of in between of building six stories, I can still ask the other party for to pay me the amount that should have been paid to me for building four floors. Okay, so this it means that what I've done, I should be paid for it. Okay, that is quantum merit. Let's see the quick recap of every type of remedy. First one is damages. That means to pay for the real loss caused. Second is liquidated damages, a fixed amount agreed in advance. Third is specific performance. Court orders the promise to be kept. Next is injunction. Court orders a wrong act to stop in between. Okay, decision, which means to cancel the contract entirely. After that, it's restitution, that give back what was received, and quantum merit, which means pay fairly for work already done. So these are the basic remedies that can come into a law of contract. You would obviously study more about them when you get into law school, law of contracts, which is the Indian Contract Act. These are the things, basic concepts you need to know for CLAT, because it's a very recurring topic in CLAT papers and even your mocks. Thank you so much for watching the video. We would be coming up with more similar videos related to legal reasoning topics and more soon on the channel. Thank you so much for watching.